All rise. Oui, vous levez. The International Criminal Court is now in session. Lord John de Cour Panel International at O8. Please be seated. Veuillez vous asseoir.
Good morning, everyone. Madam Court Officer, can you kindly mention the case?
Good morning, Madam President, Your Honors. The situation in the Central African Republic 2, in the case the prosecutor versus Mohamed Said Abdelkani, case reference ICC 0114-0121, and we are in open session.
Thank you very much, Madam Court Officer. Can I ask the parties to introduce themselves, starting with the prosecution?
Bonjour, Madame la Présidente, Madame, Messieurs les juges. Le bureau du procureur est représenté aujourd'hui par moi-même, procureur adjoint Mme Mandiaye Niang. À mes côtés, j'ai Madame le substitut principal, Olo Makwaya. J'ai les substituts, M. Thomas Bifouoli, Madame Marie-Jeanne Sardacci, Madame Brunhilde Le Bailly et Madame Vanessa Gray. J'ai aussi les substituts adjoints, Madame Sagnon Ndaguiré et Madame Anousha Rao. Et enfin, j'ai les analystes, Madame Hilary Daye et Madame Alessia Vitello. Merci.
Thank you very much, Mr. Prosecutor. Representative for the victims, Ms. Pele, can I hear you, please?
Merci Madame la Présidente. Les victimes sont représentées par Maître Gilles Dibert, Bécoy, à mes côtés, par Tars von Litzenborg et par Adeline Bédoucha et par moi-même, Sarah Pellet, conseil au bureau du Conseil public pour les victimes.
Thank you very much, Ms. Pele. For the defense, Ms. Nari, please.
Merci Madame la Présidente, bonjour. Alors, à côté de moi, nous avons Maître Jacobs et Maître François Jacquemin. Derrière moi, nous avons Emma Conti, Emma Roux-Houck et Agathe Saint-Giron. Et nous avons aussi dans la cour en ce moment qui nous suivent du bureau, Fiana Gantry et Nolwenn Moniquet. Et quant à moi, je suis Jennifer Naouri, conseil principal de M. Saïd.
Thank you very much, Ms. Naouri. And for the record, I do take note that Mr. Said is in court with us. A very good morning to you, Mr. Said. I hope I see you well.
Oui, bonjour, Madame la juge présidente.
Good morning. I welcome everyone in and around the courtroom, as well as those following online, in particular those in the Central African Republic, to this hearing. Now, over the next few days, we will hear the closing statements of parties and participants in this case. As set out in the fourth direction on the conduct of proceedings and the scheduling order for the closing statements, we will start with the prosecution, which has been allotted 90 minutes to respond to any specific points raised in the defense's closing brief, followed by 60 minutes to summarize its case and make final submissions. We will then hear from the common legal representative of victims, who has 30 minutes for her final submissions. The chamber will then adjourn for the day, and we will hear from the defense tomorrow. Before I turn to the prosecution, I have a few housekeeping matters to bring to your attention. Now, the registry will be monitoring the time and will inform the chamber when the allotted time is due to end. Furthermore, the chamber expects the parties and participants' submissions to be in public session. In this regard, the chamber recalls its directions in relation to the closing briefs, in which it allowed the parties and participants to refer to confidential information as long as doing so does not lead to the identification of protected witnesses or otherwise compromise their security. Lastly, I remind everyone of the importance to speak slowly for the interpreters and court reporters. With that, I give the floor to the prosecution.
Merci, Madame la Présidente. Madame la Présidente, Madame, Messieurs les juges, dans quelques semaines, plus précisément le 28 décembre prochain, la République centrafricaine organisera des élections pour choisir de nouveaux représentants pour ces institutions. Et il est heureux qu'au moment où ce pays, encore meurtri par la guerre civile des années 2012 à 2014, cherche à clore ce chapitre douloureux de son histoire. Donc je disais qu'il est heureux que la Cour pénale internationale soit au rendez-vous. Un rendez-vous peut-être un peu décalé, mais un rendez-vous qui n'est pas tardif. Un rendez-vous pour dire aux contemporains de ce conflit que la conquête ou la conservation du pouvoir ne saurait justifier le massacre d'une partie de la population. Donc cette partie de la population réduite à une identité ethnico-religieuse et qui pour cela aura été déclarée ennemie du peuple centrafricain. Bon, selon le camp politique auquel on appartient. Ces camps politiques, c'est le groupe Seleka, c'est le groupe anti-Balaka. J'étais ici, Madame la Présidente, Madame, Messieurs les juges, j'étais ici dans cette même salle d'audience il y a à peine 2 mois pour recueillir le verdict dans l'affaire Yakatom Ngaïsona, 2 figures emblématiques de la faction anti-Balaka. Et aujourd'hui, j'ai l'honneur de conduire l'équipe du bureau du procureur pour présenter nos réquisitions finales contre une figure de l'autre faction, chez Mohamed Saïd Abdel Kani. Les charges que nous portons contre M. Saïd concernent les violences inouïes, des persécutions contre des individus considérés ou perçus comme pro-bozizés et des crimes atroces perpétrés par les Seleka en 2013, particulièrement dans la capitale, Bangui. Dans nos différentes écritures déposées devant votre Chambre et dans nos plaidoiries dans ce procès, l'accusation a présenté des preuves démontrant, au-delà de tout doute raisonnable, que l'accusé, M. Saïd, a perpétré, avec d'autres, ordonné ou encouragé les 7 chefs d'accusation de crimes de guerre et de crimes contre l'humanité pour lesquels il est aujourd'hui poursuivi. Madame la Présidente, Madame, Messieurs les juges, ma collègue Makwaya, dont vous êtes familière parce que c'est elle qui a conduit ce procès devant vous et qui prendra la parole à ma suite, elle vous dira en quoi la preuve que nous avons produite établit les charges retenues contre M. Saïd. Et comme vous l'avez aussi prescrit, elle s'évertuera à répondre à certaines des questions qui ont été posées dans les mémoires de la défense. Et je me dois de souligner encore que cette phase de plaidoirie d'aujourd'hui est une étape très importante de l'affaire. C'est un moment de la procédure qui nous rapproche de plus en plus de cette phase décisive d'établissement de la vérité judiciaire sur les faits très graves reprochés à l'accusé. Mener à terme les poursuites à l'encontre de M. Saïd et situer les responsabilités sur les événements douloureux ayant déchiré la République centrafricaine entre le 12 avril et le 30 août 2013, ceci reste plus que jamais nécessaire. Durant ce procès, notre bureau n'a jamais varié dans sa démarche. Nous avons tout mis en œuvre pour que justice soit rendue aux victimes des atrocités perpétrées dans cette situation par toutes les parties au conflit. Nous avons pu avancer dans cette procédure grâce à la contribution essentielle de tous ces acteurs clés. Et vous avez pu entendre, mesdames, messieurs les juges, en 121 jours d'audience, les récits de 81 témoins, dont 25 qui ont comparu ici, donc que vous avez entendu viva voce, et 33 en vertu de la règle 68.3. Ça a été un gros travail, ça a été vraiment un gros travail. Mais ce travail titanesque n'a pu être effectué que grâce à la participation de tous, au nombre desquels je veux citer les victimes et aussi les communautés affectées en Centrafrique. Elles ont collaboré avec courage et détermination à l'œuvre de justice. Les autorités centrafricaines aussi, les acteurs de la société civile aussi. Et ensuite, aucun des acteurs, je dois dire, n'a été en reste. Et je voudrais encore ici leur rendre hommage. Madame la Présidente, Madame, Messieurs les juges, au cours de ce procès qui s'est ouvert le 26 septembre 2022, comme je l'ai indiqué, l'accusation a présenté des preuves que nous croyons solides et établi au-delà de tout doute raisonnable que l'accusé, M. Saïd, a perpétré, ordonné ou encouragé les crimes visés dans ces 7 chefs d'accusation pour des motifs relatifs aux crimes de guerre et crimes contre l'humanité commis par la faction Seleka. La scène de crime. La scène de crime, c'est l'Office central de répression du banditisme, connu sous le sigle de OCRB, et plus familièrement OCRB en anglais. Il a été déterminé, au-delà de tout doute raisonnable, que M. Saïd est responsable de ces graves crimes par sa contribution essentielle à un plan commun avec d'autres membres de haut rang de la coalition Seleka. Ces crimes ont visé les partisans présumés de Bozizé qui ont été arrêtés, détenus et se sont vus infliger de mauvais traitements de tous les ordres à l'OCRB. Vous entendrez de mes collègues la description du rôle important joué par l'accusé en tant que membre de haut rang de la coalition Seleka, à la tête des opérations au sein de cet office. L'accusation reviendra sur les extraits de témoins clés du bureau du procureur qui ont subi d'atroces sévices commis par l'accusé et les Seleka lors de leur arrestation ou lors de leur détention dans les locaux de cet office. L'accusation vous présentera des documents écrits signés de Saïd lui-même, documents qui attestent du plein contrôle qu'il exerçait sur les victimes détenues dans des conditions inhumaines. Vous entendrez les extraits de témoignages établissant sa participation directe dans les sévices infligés. Les victimes de ces crimes ont été pour cible, elles ont été arrêtées de manière arbitraire pour des motifs d'ordre politique, ethnique, religieux ou basés sur le genre. Les preuves présentées dans ce procès établissent que les victimes de ces crimes commis par M. Saïd étaient principalement de confession chrétienne et de sexe masculin. Elles appartenaient aux ethnies Gbaya, Manjda ou Banda et résidaient majoritairement dans les quartiers de Bangui, tels que le quartier Boy Rab. Madame la Présidente, Madame, Messieurs les juges, les faits qui vous ont été présentés par l'accusation se sont déroulés dans le cadre d'un conflit armé non international qui a eu pour théâtre Bangui à travers d'intenses hostilités entre Seleka et forces proboscisées entre la fin 2012 et le 10 janvier 2014 au moins. L'accusation a établi qu'au cours de ces hostilités, des femmes, des enfants, des personnes âgées et des personnes en situation de handicap ont été victimes de terribles exactions commises par les Seleka. Parmi les nombreuses victimes, des femmes ont été violées, parfois en présence de leurs enfants, au motif d'une prétendue affiliation de leur mari avec les forces pro-bosisées. De jeunes enfants d'à peine 4 ans ont dû être amputés suite au tir d'un engin explosif sur une église dans un quartier populaire considéré comme favorable à Bosisé. Les souffrances aiguës de toutes les victimes et de leurs proches résonnent encore dans ce prétoire. Les attentes de justice dans ce procès peuvent encore se lire sur le visage de ces victimes. Madame la Présidente, Madame, Messieurs les juges, ce jour est un moment fort, d'une importance cruciale, d'une importance capitale pour les victimes, les communautés affectées et la population centrafricaine qui attendent depuis longtemps que justice soit rendue dans cette affaire contre M. Saïd Abdelghana. Je suis confiant que cette justice leur sera rendue au terme de nos réquisitions et des différentes réponses des parties que vous entendrez aujourd'hui et demain. C'est sur ces mots que je conclus mon propos liminaire pour passer la parole à ma collègue Madame Olo Makwaya. Et je vous remercie de votre attention, Mesdames, Messieurs les juges.
Thank you very much, Mr. Prosecutor. Ms. Makwaya, please, can we hear from you? Ms. Makwaya, just a moment. Maybe let's have a correction to the transcript. I don't know the right reference point, but I'm made to understand that both in the French and English version of the transcript, we have at a particular line 13 the mention of the year 2014. I think the prosecutor was trying to talk in respect of responsibility for the offenses committed in the Central African Republic between the period 12th April and 30th of August. But the year that we have there is 2014. Can you confirm whether or not you meant, Mr. Prosecutor, 2014 or 2013 of August?
C'était bien 2013, Madame la Présidente.
Thank you very much for that clarification.
Parce que la période que nous vivons en 2013.
Thank you very much for that clarification. Ms. McQuire, please, can we hear from you?
Thank you, Madam President. Your Honors, good morning. Before I proceed, Madam President, a bit of a housekeeping matter. Our evidence channel is not working. At this portion of our presentation, we won't be showing any slides, but we missed the opportunity to show a few with the DP. If we could be assisted, we'll be grateful.
The court officer will come to your rescue in that regard. Thank you.
Before I start, Your Honors, I would like to delineate the manner in which we shall be proceeding with addressing some of the issues raised by the defense in their closing brief. I shall start by addressing you on some issues related to evidentiary matters. I shall be followed by Ms. Anusha Rawa, who shall address issues with respect to the non-international armed conflict, who will be followed by Ms. Marie-Jeanne Sardachi, who will address you on 4 incidents. And we shall finish with Mr. Thomas Bifoli, who shall address you on matters raised with respect to the mode of liability. And then when we come to the prosecution case, I shall be summing up with Ms. Sanyu Ndagiri. Having said that, Madam President, I shall now start. Madam President, Your Honors, the defense has raised multiple issues and assertions with respect to the knowledge of Mr. Said on the running, on the constitution of the former led Seleka government and even the coalition. We have a very simple answer to that, Your Honors. This case is not a case against the Seleka coalition. It is not a case against the government led by the Seleka coalition. It is the case against Mr. Mahmoud Said Abdel Khani for his act and conduct during the charged period. Whereas you've heard from Mr. Prosecutor, he faces 7 counts. I will start with an evidentiary issue also repeated continuously in the defense brief with respect to the evidence presented by the prosecution that it claims lacks corroboration, lacks or contains inconsistencies in support of its general contention on the weakness of the prosecution evidence. The defense, Madam President, Your Honors, also takes issue with what it deems the lack of forensic evidence, therefore weakening the presented case. Your Honors, here again our position is quite simple. These issues are settled in law, and Your Honors have a broad discretion when you come to the assessment of the evidence presented before you, because you will do so in a holistic manner to issues pertaining to credibility and the reliability of witness evidence. Further, Madam President, corroboration is not required as a matter of law. And here I would like to refer Your Honors to the Lubanga appeal judgment at paragraph 218, the Bemba et al. Appeal judgment at paragraph 1084, and also an appellate decision in Gujolo at paragraph 184. And even the Rome Statute does not require corroboration before Your Honors can consider a piece of evidence. Madam President, Your Honors, inconsistencies in witnesses' evidence we submit constitute no bar to reliability. And again, I would refer you to the same appellate decisions, starting with Ngujolo in support of this assertion, para 168, then Taganda appeal judgment at para 806. Now, with respect to whether or not the lack of forensic evidence weakens the prosecution case, Madam President, the answer is no. Forensic evidence is not required to prove a crime falling within the jurisdiction of the statute. And here, Your Honors, I'd like to refer you to the Ongwen trial judgment at paragraphs 1471 to 1472. We also refer you to the Musema trial judgment and sentencing at paragraph 52. I forgot to inform Your Honors, all these decisions are listed in our Book of Authorities for your ease of reference. Madam President, in assessing the evidence that has been presented before you, Your Honors would recall that many of the witnesses during the trial were victims of Said's horrendous crimes. For example, P547, 481, and others you had the opportunity to hear. In this regard, we shall also recall the jurisprudence available that states the impact of trauma and the passage of time may have a contributing factor to a witness's recollection. Both these factors can be, Your Honors, a source of unclarity in the evidence that is given. We submit, Your Honors, that when you assess the totality of the prosecution evidence, you should give due consideration and appropriate allowance in factoring in all these indicias that may impact the testimony of a witness. The evidence should be assessed in its entirety, holistically, and not piecemeal. I here refer you to the constant case law we also cited in our table of authorities, found in Bemba et al. Trial judgment at paragraph 203, also in the Al-Hassan trial judgment at paragraphs 40 to 41, in the Yekatom and Gaisona trial judgment at paragraph 201, and again in the Ongwen trial judgment at paragraph 258. Your Honors, it's our submission the defense adopted a fragmented approach to the evidence led by the prosecution. It has dissected the evidence to feed into an argumentative line which is not supported by the law, and as a result, their assessment failed to pierce the solidity of the body of credible and reliable evidence presented by the prosecution during the trial that we submit establishes Mr. Said's responsibility in the crimes as charged. I will only refer you to the paragraphs where these contentions are made in the defense brief, Madam President, in the interest of time. I'm quite aware we've got very limited time. These allegations or assertions made by my friends across the bar can be found at paragraph 95, 120, 127, 137, 417, 142, etc., with respect to corroboration. And again, paragraphs 317, 324, 328, 433, etc., on inconsistencies. Now, with respect to the lack of forensic evidence, this is also mentioned at paragraph 4. Madam President, Your Honors, you may recall the evidence of Mr. Prosecution Investigator, who clearly testified that it was not always necessary to conduct forensic evidence if other pieces of direct and corroborated evidence existed. And he gave an example of a particular incident where he was being cross-examined on. In conclusion on this topic, Madam President, it's our submission that the defense assertions pertaining to issues which are in fact some of the many pertaining to issues which may be impacted by some of the many factors you will find in the cited case law should be taken into consideration when you do a holistic review of the prosecution evidence and not undertake the approach taken by the defense of isolating or dissecting line by line, piece by piece. I shall now turn, Your Honors, to another issue raised in the defense brief with respect to incidents D and K. Your Honors, recently on the 20th of October 2025, we clarified to the Chamber that incident D and K are properly before the Chamber and the prosecution has no intention whatsoever to withdraw these incidents for your consideration when you make your deliberation with respect to the evidence you've heard. Both incidents are found in the DCC, have been confirmed by the pretrial chamber at paragraph 29D and K of the decision on the confirmation of the charges. As we identified in the clarification response, Madam President, there is evidence on record, ample evidence on record to establish both incidents. Granted, Madam President, Your Honors, the two victims of these allegations did not appear before you because they declined to testify for the reasons we presented to the chamber. Nevertheless, the allegations have been proved. The allegations have been proved with the other evidence that is available on record. As for the allegation that, as for the contention concerning the absence of evidence on Mr. Said's role and responsibility in relation to both these incidents, the prosecution refers the chamber to the evidence mentioned in paragraphs 105 and 123 of its closing brief on Mr. Said's role at the time of relevance to the charges. Based on this evidence, Your Honors, it is our case that a reasonable inference can be drawn on Mr. Said's individual criminal responsibility in relation to the detention of P0645 and P2172 at the OCRB. I shall now turn to another issue raised by the defense, and this time, Madam President, Your Honors, it's with respect to SEDAD as a non-charged incident for the purpose of the contextual elements of crimes against humanity. Your Honors would recall that evidence related to the SEDAD has been set out in paragraphs 72 to 75 of the prosecution's closing brief in the section on contextual elements of the crimes against humanity. The defense asserts at paragraph 144 and 146 of its brief that the prosecution reintroduced charges by considering evidence on the SEDAD to establish that an attack took place pursuant to Articles 7.1 and 7.2 of the statute. This defense position, Madam President, Your Honors, is in apostolate. The prosecution did not reintroduce the charges by considering evidence on Sedad. As set out in the court's jurisprudence, it is permissible for the chamber to consider non-charged incidents for the purpose of an attack pursuant to Article 7.1, providing they fall within the temporal and geographical scope of the charges. We refer Your Honors here to the decision on the confirmation of charges in the Ntaganda case, also in our Book of Authorities, more particularly at its paragraph 23. After all is considered and said, Madam President, Your Honors, the defense at the end of the day has been on notice. The defense has been on notice of the temporal and geographical scope of the attack under consideration by Your Honors at paragraph 60 of the confirmation of charges decision and at paragraph 50, and I'll stop there, at paragraph 60 of the confirmation of decision of the charges. This took place in 2021. They've been on notice, ample notice for more than 2 years. And I will just give a bit of context, Madam President. This attack is described as a cause of conduct taking place from at least April 2013 until at least November 2013 against the civilian population in Bangui perceived to be Bozize supporters. So it's covered by the temporal scope. Your Honors, in the case at bar, this contention does not warrant any further consideration. There is no doubt that the detention and ill treatment of perceived pro-Bozize supporters at the Sedad between mid-September 2013 to 8th November of the same year in Bangui falls squarely within the temporal scope and geographical scope of the attack, as defined in paragraph 60 of the confirmation of charges decision. I shall conclude on this point, Your Honors, by stating that the prosecution committed no error in arguing that this non-charged incident forms part of the Seleka attack, which took place against perceived pro-Bozize supporters in Bangui from at least April 2013 to November of the same year. I'm now turning to another contention raised by the defense in its brief, and this time it's with respect to the scope of application of counts 2 to 4. At paragraphs 562 and 563 of its closing brief, the defense contests the scope of application of counts 2 to 4 as summarized in the closing brief. It contends, Your Honors, that the pretrial chamber only confirmed counts 2 to 4 in relation to 5 incidents. And these are incident B, E, H, M, and Q. Madam President, Your Honors, the defense proposes an erroneous reading to the charges we submit. Counts 2 to 4, as formulated in the decision on the confirmation of the charges, contains a non-exhaustive list of the confirmed incidents. And I'm going to repeat this. It contains a non-exhaustive list of the confirmed incidents, including as summarized in quotation mark, which are now under consideration by Your Honors chamber. Going back to the decision on the scope of the charges, ICC-01/14-01/21-472 at paragraph 25, Your Honors, you have confirmed that the scope of the charges, that the scope of the charged crimes in the present case is limited to the specific incidents listed in the confirmation decision. However, for the purposes of counts 2 to 4, this includes not only the victimization expressly mentioned therein, but also the victimization of other persons, provided, Your Honors, and we put emphasis there, other persons, provided they were also listed in paragraph 29 of the operative part of the confirmation decision. Your Honors, according to the pretrial chamber, the scope of counts 2 to 4, moreover, was not limited to the incidents listed in the confirmation decision. An interpretation supported by the trial and appeals chamber in Ntaganda. Would like to refer Your Honors to the pretrial chamber's decision at ICC-01/14-01/21-396, paragraphs starting 16, ending at 25, and also to the appeals judgment in Ntaganda at paragraph 326, and the trial judgment in Ntaganda at paragraphs 37, 40, and 41. Subsequently, Your Honors, it's our submission that the defense contention should not be given any further consideration. In its brief, Madam President, Your Honors, the defense has also mischaracterized or conducted an assessment of the presented evidence by prosecution witnesses in a flawed manner. It has repeatedly mischaracterized the evidence in an attempt to discredit the evidence presented by the prosecution to establish the crimes charged. Your Honors, in the 81 witnesses presented before you, we presented a solid body of evidence for your consideration when you retire to deliberate. We have only chosen a few salient examples from the defense brief to demonstrate the flaws or the mischaracterization of the evidence they've undertaken. For example, Madam President, at paragraphs 180 to 184 of the defense closing brief, the defense contends that P1339 did not know what was happening in Zongo, nor participate in the discussions between soldiers The manner in which this assertion is put forward totally mischaracterizes the evidence of the witness. It took a line of one of his responses to a question and then ran with it. The evidence on the anti-Balaka has been assessed in isolation. Once again, not in the totality of the witness's entire evidence, hence the flawed assessment by the defense. You may recall, Your Honors, that this witness testified that after the March 2013 attack, he fled to Zongo, where he saw soldiers discussing among themselves. While he was not aware of everything that was going on, he testified about his interactions with the individuals that ultimately led him to join the anti-Balaka. And here I would refer you to transcript 131, 23, column 10-22. We do not want to delve any further into the evidence of this witness. Now, turning to paragraphs 5, 20, and 24 of its closing brief, the defense also contends that witness P547, that the account of witness P547 contains no reference to Mr. Said, the accused before you today. This, we submit, is another mischaracterization of the evidence. P547 testified that he saw Said on several occasions at the OCRB, identified him on photographs shown here in court, as referred to in paragraph 219 of our closing brief, and testified, Your Honors, at length before you about his role and control over the detainees at the OCRB. Your Honors, here we refer to excerpts of transcript T12 and T13, or submitted to you before this hearing. Madam President, P547's evidence needs to be assessed in the context of other evidence on detentions at the OCRB at the time of the charges. For instance, his evidence on the underground cell is corroborative of the evidence of numerous prosecution witnesses, such as P3056 and P2478, to cite just a few. Your Honors, I submit that the defense not only failed to consider the evidence in its totality, but it also presented an erroneous reading of the evidence in support of its assertions. Having said that, Madam President, this concludes my part on the defense brief, and I now invite Ms. Anusha Rawa, who shall be speaking to issues raised with respect to the non-international armed conflict. Thank you for your attention.
Thank you very much, Madam Prosecutor. Ms. Yawawa, we'll listen to you, please. Thank you.
Thank you, Madam President. Your Honors, good morning. My submissions today address the principal issues arising from the defense brief, notably on war crimes. As the Chamber is aware, the prosecution's full position on war crimes is addressed at pages 5 to 27 of the prosecution's closing brief. Your Honors, the defense arguments on war crimes fall in four broad categories. First, the evidentiary weight to be attached to the testimonies of defense witnesses P0015 and P0022. Second, the alleged lack of organization of the Anti-Balaka and the Seleka. Third, the defense contention that there was no armed confrontation existing prior to September 2013. And fourth, the defense submissions on Mr. Said's knowledge. Your Honors, I would now turn to the first issue. Your Honors, at paragraphs 157 to 165, the defense contends that the prosecution delivered its narrative without presenting the witness with facts. Respectfully, Your Honors, the prosecutions disagree. Regarding P0015, Your Honors will recall that the witness was called as a witness of facts. The witness was duly confronted with all the relevant facts during cross-examination. However, her answers revealed significant gaps in knowledge concerning factual matters. And for this, I refer Your Honors to the English transcript T136, pages 4 to 6. In this transcript, you will recall, Your Honor, P0015 admitted having no information at all as to whether any peace agreement was signed
between the Anti-Balaka and the Seleka after the March 2013 attack. She even had no knowledge as to what had happened to the pro-Bozizé forces after they had fled. In fact, she admitted that her research focused on the armed elements which remained in the country. Likewise, Your Honours, for P0022, the same deficiencies apply. This witness was also a witness of fact. He came to testify, yet he had no meaningful knowledge as to the events related to this case. Your Honours will recall that the witness was in the Central African Republic for only 2 weeks. And I'll here refer his responses in transcript 134, the English version, pages 57 and page 70. The witness admitted never having even heard about the OCRB. The witness said he had no knowledge about the Seleka bases in Bangui. By contrast, Your Honours, we have on record overwhelming evidence from insider witnesses as well as victims, which contradict the defense version on every material point. I refer by way of example here the evidence of P0291, P2232, P1339, and other Seleka insider witnesses such as P2105, P1167, and P2563, whose evidence give us an aperçu on what had happened actually in the Central African Republic in 2013, and as well as matters pertaining to their personal knowledge. Therefore, Your Honours, prosecution submits that neither of these two defense witnesses were capable of undermining, at any rate, the substantial evidence on record from prosecution. This now brings me to the second issue, the alleged lack of organization of the Anti-Balaka. It is defense contention, Your Honours, at paragraphs 180 to 184 and 223 to 228, that the Anti-Balaka lacked the organization, structure, logistical, or operational capacity. Your Honours, the evidence demonstrates the opposite, and this for the following reasons. First, it is prosecution submission that the pro-Bozizé forces, which later became the Anti-Balaka, maintained an effective command structure adapted to their circumstances. It is not disputed that prior to the 24th of March 2013, Bozizé commanded the state armed forces, namely the FACA. Therefore, these forces already enjoyed the legal presumption of sufficient organization. Now, referring to the case of Dilalich, trial judgment, paragraph 231, the prosecution submits that whatever the precise legal classification of these forces loyal to Bozizé, in the immediate aftermath of March 2013, they represented part of the same party that had been subject to Bozizé's control. That is, the party opposing the Seleka. Your Honours, after the 24th of March 2013 attack by the Seleka, the pro-Bozizé forces had set up a command structure with military commanders. They were known as the Comzone, and you have heard P2232's testimony on this. He testified that this term was copied from the military model. I'll here refer Your Honours to the transcript T02, pages 33 and 37, the English transcript, where P2232 explained that Mokom was the coordinator of operations. And I quote, he prepared the Comzones for the attacks. He taught them combat tactics on the phone. The Anti-Balaka leaders were able to communicate among themselves through telephone, and they were able to coordinate. Using the words of P1339, there were very good communications among the Comzones. The pro-Bozizé were organized into sections, as explained by P1339 in English transcript T132, pages 19 and 20. And they were also identified by gris-gris. In all, Your Honours, the clear objectives of the anti-Balaka was to drive the Seleka out of the country and regain power from them, as explained by P2232. My next point is that contrary to what defense asserts at paragraphs 217 to 220, the pro-Bozizé forces did have the logistical capacity. They had the capacity to train and recruit new elements. P1339 testified that after retreating to the provinces, volunteers joined and they were trained on how to use weapons. They were in fact trained by former FACA soldiers. Weapons were therefore provided to the members, and as explained by P2251 and P0342, the anti-Balaka used weapons, albeit traditional weapons, fashioned by themselves, arrows and knives. They had pan lids, they had grenades during the attacks with the Seleka, as explained by P2251. The pro-Bozizé forces, Your Honours, also made use of various means of communication. As submitted, they made use of telephone. They also made use of emails. And I will here refer to the several email communications of key actors between March and November 2013, showing the pro-Bozizé forces eventually taking steps to reorganize, resupply, and rearm their forces. And here, paragraph 41 of the prosecution closing brief addressed this issue. My next point is that, contrary to defense assertions, the pro-Bozizé forces had the operational capacity to carry out military attacks. Your Honours, the reorganization of the pro-Bozizé forces after March 2013 actually assisted them to coordinate attacks. Your Honours heard evidence that on 18 August 2013, the pro-Bozizé forces launched an attack at the National Assembly in Bangui to disrupt the second inauguration of Georgia. Actually, Your Honours, the pro-Bozizé forces had the capacity to act on the intelligence collected, which they used during the attacks. And as explained by the former Prime Minister of Central African Republic, P0291, the anti-Balaka had organized themselves in the provinces, and they launched several attacks between August and September 2013. Additionally, Your Honours, contrary to what defense contends, that there has been inadequacy of funding of the anti-Balaka forces, prosecution submits that there is evidence on record about the funding to this organization. As explained by P2232, funding came to the anti-Balaka from the House of Mokom being provided as guarantee, as well as money transferred from Cameroon. I'll here refer to his testimony at English transcript T102, pages 40 to 41. He further explained, and I quote, "They would get money because during fighting, some would flee and leave their goods behind, vehicles or other possessions. So they would use those things to get money." Therefore, the prosecution submits, Your Honour, based on these evidence adduced, the pro-Bozizé forces were duly organized. I now turn to the next point, the defense contention that the Seleka lacked organization. Prosecution submits, Your Honours, that at all material times, and even before the capture of Bangui in March 2013, the Seleka was sufficiently organized so as to establish the existence of a non-international armed conflict. I'll here refer, Your Honours, to paragraphs 21 to 31 of the prosecution closing brief. First, the prosecution submits that the Seleka did have the capacity to conduct military operations. Your Honours heard evidence from Seleka insiders that in March 2013, Seleka leaders, including Chitoja, met at Sibut. They planned and coordinated the attack to capture Bangui. The Seleka elements then marched towards Bangui and entered the city from different directions. And here, the exhibit bearing reference car REG 0002-0035 becomes relevant, which is the map on which P2105 annotated regarding the routes which the various commanders took with their troops down to Bangui. On 24th of March 2013, the Seleka launched an attack on Bangui. They overthrew the Bozizé government. This shows the Seleka's military capacity to carry out a coordinated operation, leading to even overthrowing a government in power. My next point is that the Seleka controlled an important territory in Central African Republic, including its capital city, Bangui, by 24th March 2013. Your Honors, after the Seleka had taken power in March 2013, they started controlling an even more substantial territory of the Central African Republic than before. They had then set up a checkpoint system to control movement of people within their territory. I'll here refer to the Boirabe incident in April 2013 and the PK9 checkpoint incident in July 2013, where the Seleka blocked entry and exit points with armed men, preventing the population from escaping violence. To maintain their power, the Seleka established various bases, such as the OCRB Central, OCRB Ngoussiment, Cedad, Camp de Roux, Camp Kassai, and Sapeurs-Pompiers. Your Honors, another factor borne out by evidence is that the Seleka had a proper command structure. The evidence on record shows that before he became president, Chitoja, the leader of the Seleka, was even giving orders to Seleka members, and they were being complied with. For instance, you have heard insider witnesses P2563 and P1167 stating that the March 2013 attack was carefully planned and that instructions came from Chitoja. Your Honors, upon gaining power, the Chitoja-led government appointed Seleka members to key posts, such as Security and Finance Ministry. This was done through official presidential decrees. I'll here refer Your Honors to the CAR Presidential Decree CAR OTP 2004-1597. A National Security Council was also established through a presidential decree. And senior Seleka officials were holding weekly meetings to assess the security matters in the Central African Republic. My next point, Your Honors, is that there is also evidence on record that the Seleka had significant logistical capacity. On this, Your Honors heard several witnesses, namely P0338, P3056, P1339, P2563, who explained that during the March 2013 attack, the Seleka were well equipped. They had military-type vehicles, weapons, and other equipment. Several photographs have been adduced as evidence, such as the photograph bearing reference number CAR OTP 2074-1124, as well as CAR OTP 2042-4942. P2105, in fact, testified that each Seleka troop had an AK-47 and heavy weapons used by the Seleka. They possessed satellite phones, the Turayas, which the leaders used, the Seleka leaders used to communicate among themselves and plan the advance upon Bangui. The Seleka were also provided with identification badges issued with stamps of Seleka and signed by Adam. I'll here refer to the identification badges on record for P2105, P1737, and P2563. Moreover, Your Honours, there were military camps, training camps established by the Seleka to provide training to the elements. The Seleka had a system of food distribution across the bases, and uniform arrangements were made for them. The OCRB Seleka also wore uniform and blue armbands. Your Honours, all these evidence on record clearly demonstrate that the Seleka did have a command structure and military capacity to carry out successful operations. I now turn to the third point of contention by the defense, that there was allegedly no armed confrontation between the Anti-Balaka and the Seleka until September 2013. At paragraphs 243 to 247, Your Honours, the defense argues that there was a lack of intensity of conflicts between 24th of March 2013 and end of August 2013. The prosecution respectfully disagrees. Your Honours, it is settled law that the intensity and protracted armed conflict criterion do not require the violence to be continuous and uninterrupted. Rather, the essential criterion is that it goes beyond isolated or sporadic acts of violence. I'll refer Your Honours here to the trial judgment of Bemba at paragraph 140. In the present case, as already submitted before, there was an initial conflict between the Seleka and the pro-Bozizé forces in the late 2012. This led to the attack in March 2013 and overthrowing of the Bozizé government in March 2013. Therefore, this initial conflict, Your Honours, transcended mere isolated or sporadic acts of violence. The conflicts were so intense that this even prompted the international community to intervene. A ceasefire agreement was signed between the parties on the 11th of January 2013, but it was short-lived. On this issue, Your Honours, I refer to the trial judgment of Tanganda, paragraph 723, where it was held that the signing of ceasefire agreements is an indication that the situation being addressed by the agreement was of a significant intensity, which is precisely the case here. When the Seleka took power on 24th of March 2013, the pro-Bozizé forces did not surrender. They did not sign any peace agreement with the pro-Bozizé forces. The pro-Bozizé forces, on the other hand, regrouped. They went to the provinces, and as P2232 testified, the Anti-Balaka was formed a month or two after the Seleka took power on the 24th of March 2013. Therefore, Your Honours, the hostilities against the Seleka continued. And I'll here refer to the Boirabe incidents of April 2013, as well as to the incident, the attack on the 18th of August 2013 to prevent Chitoja from being sworn in. Subsequently, in August and September 2013, the pro-Bozizé forces launched several attacks, as explained by P0291. Many civilians were displaced, Your Honours, and this prompted the Seleka government to deploy 0291 to Bosangoa to address the situation. I'll now refer Your Honours to the trial judgment of Bemba, paragraph 141, where it was held that international humanitarian law applies from the initiation of an armed conflict and extends beyond the cessation of hostilities until a peaceful settlement is achieved. Until that moment, international humanitarian law continues to apply in the whole territory under the control of a party, whether or not actual combat takes place. As submitted, Your Honours, when the Seleka took over power on 24th of March 2013, the pro-Bozizé forces did not sign any peace agreement with the Seleka. In fact, Your Honours, despite being in power, the Seleka were laboring under constant fear of attacks from the pro-Bozizé forces. This prompted the Seleka to monitor pro-Bozizé forces and gather intelligence on their activities. For instance, Your Honours, the Seleka members were sent on mission to Zongo by the then Minister of Public Security, Adam, in the period May to August 2013. The purpose was to collect intelligence on the activities of the pro-Bozizé forces. I'll refer here to the several ordres de mission quoted at paragraph 38 of the prosecution's closing brief. I also refer, Your Honours, to the different military intelligence reports which the prosecution has referred to at paragraph 25 of its closing brief. Your Honours will also recall that as per P0291, security meetings were being held on a weekly basis to address this situation. Consequently, Your Honour, prosecution submits that international humanitarian law continued to apply throughout the whole of 2013, including the charge period. I now turn to the final contention raised by the defense in their closing brief, challenging Mr. Said's knowledge on the existence of a non-international armed conflict between April and August 2013. Your Honours, based on the evidence submitted between 24th March 2013 and 5th of December 2013, the Seleka remained active in the Central African Republic. They continued to train the elements. They continued to exercise military power against the Central African Republic population as well as pro-Bozizé forces. And they left Bangui after President Tutoja had stepped down from his position. And that was on the 10th of January 2014. Now, regarding Mr. Said, after the Seleka had taken over Bangui in March 2013, he was appointed head of the OCRB by Adam, who was the then Minister of Public Security under the Seleka-led government. Therefore, Mr. Said's power flew directly from Adam. There is evidence on record that Mr. Said had cooperated with other Seleka leaders as of April 2013 in order to suppress resistance to the Seleka regime. In these circumstances, Your Honours, prosecution submits that neither Mr. Said nor any relevant factual perpetrator could have failed to know of the existence of an international armed conflict, of a non-international armed conflict. To conclude, Your Honours, defense contentions raised on war crimes in their defense brief hold no water in light of the substantial evidence adduced by prosecution. Therefore, the prosecution submits that, based on the evidence, it has proved beyond reasonable doubt the existence of a non-international armed conflict during the charge period, as well as the commission of war crimes within the meaning of Article 8 of the Rome Statute, as well as Mr. Said's knowledge to these war crimes. With this, I end my submissions, and I now pass the floor to Ms. Marie-Jeanne Sardachi. Thank you, Your Honours.
Can I please remind the parties in the prosecution to slow the pace, please, for the assistance of the interpreters. Please speak slower. Thank you very much.
Thank you very much, Counsel. Ms. Saudache, we have about 12 minutes to the first break, just for you to know. We will listen to you, please.
Thank you, Madam President. It should be over 15 minutes, so if you allow us to speed over the break a little bit.
I'm sure the registry would accommodate us and the defense would accommodate us if you need just 15 minutes. Please carry on.
Bonjour Madame la Présidente, Madame et Messieurs les juges. Je vais à présent répondre aux arguments formulés par la défense concernant 4 incidents qui correspondent respectivement aux paragraphes 29G, H, J et N de la décision relative à la confirmation des charges portées contre M. Saïd. Tout d'abord, s'agissant des incidents G et J, dans lesquels 2 soldats FACA sont décédés, la défense critique l'absence d'actes d'enquête médico-légale. Et je me réfère au paragraphe 464, l'incident G des écritures de la défense, et 485 pour l'incident J des écritures de la défense. Bien que l'accusation ait produit des éléments médico-légaux dans certains cas, il demeure que le droit applicable est clair et la jurisprudence constante. La preuve médico-légale n'est pas une condition sine qua non pour établir l'existence d'un crime devant la Cour. Et je vous renvoie à la règle 63.4 du règlement de procédure et de preuve et à la jurisprudence qui a été citée par le premier substitut, Olo Makwaya, en introduction, et que je ne répéterai pas. Pour l'incident G, qui est visé au paragraphe 450 à 467 du mémoire de la défense, la preuve démontre que le soldat des forces armées centrafricaines a été arrêté à Bangui par M. Saïd et ses agents. 2 témoins clés le confirment. P2504 voit M. Saïd et ses éléments mettre le soldat FACA dans leur véhicule et le témoin les a suivis jusqu'à l'OCRB. L'autre témoin, P2607, qui est un membre de la famille du soldat FACA, décrit avoir été bloqué juste avant d'arriver à l'OCRB. M. Saïd est venu dans la rue, a tiré en l'air, ordonnant à ses éléments de ne pas laisser passer P2607 et sa famille. Peu après, P2607 a pu identifier le soldat FACA, après avoir reconnu son pantalon, alors que les jambes de ce dernier dépassaient du véhicule sur lequel était inscrit OCRB. Et je vous renvoie aux paragraphes 20 et 21 de sa déclaration, à la version française qui se trouve à CAR OTP 2127 9527. Le fait que P2607 ne se souvienne pas précisément de la couleur du pantalon de survêtement du soldat ou que certaines incohérences entourent la date de déclaration du décès du soldat FACA ne remet pas en cause que l'ensemble des éléments de preuve établit cet incident au-delà de tout doute raisonnable. En ce qui concerne l'incident J, qui est visé au paragraphe 485 à 492 du mémoire de la défense, l'accusation s'appuie notamment sur 2 témoignages, dont je tairai les pseudonymes pour des raisons de confidentialité. Mais ces témoignages sont directs, détaillés et cohérents. Un des témoins décrit avec précision la scène de l'arrestation. Il relate des faits qu'il a vécus personnellement. Et je vous renvoie au paragraphe 181 à 183 de nos écritures finales. Ces détails concrets sont corroborés par le registre de la morgue et la plainte d'un membre de la famille du soldat FACA, et qui démontrent la fiabilité de son récit. À cela s'ajoute le témoignage d'un insider Seleka qui corrobore la preuve de ce premier témoin. Les 2 récits se recoupent sur des points essentiels, dont le rôle joué par M. Saïd, la violence de l'arrestation, la détention de 2 hommes, et s'inscrivent dans une chronologie logique. leur cohérence interne et mutuelle établit la crédibilité de la preuve au-delà de tout doute raisonnable. En ce qui concerne maintenant l'incident N, qui concerne une victime de l'Arbatachar enfermée dans la cellule du sous-sol, je répondrai à quelques points soulevés par la défense au paragraphe 507 à 513 de ces écritures. Au paragraphe 507, la défense affirme que la preuve apportée par l'accusation concernant cet incident est faible, car elle est fondée sur un témoignage unique qui concerne, je cite, « une personne non identifiée et à une date non identifiée ». Fin de citation. Le fait que la preuve relative à cet incident repose sur un seul témoin ne constitue pas en soi un obstacle pour fonder une condamnation. Et je ne reviendrai pas sur ce qui a été dit en introduction par le premier substitut, mais je souhaite simplement rappeler un passage du jugement Abdelrahman qui se trouve cité en page 2 de notre table des autorités. Et je citerai le paragraphe 181. Alors, il s'agit d'une traduction non officielle. Dans le présent jugement, la Chambre a tiré certaines conclusions sur la base d'un seul témoignage, dès lors qu'elle était convaincue que le témoin était à la fois crédible et fiable. Fin de citation. Ceci s'applique pleinement au témoin P1737, dont la preuve apportée est crédible et fiable. Son récit des faits est cohérent et précis. En effet, P1737, agent à l'OCRB, décrit l'arrestation de la personne visée dans les charges. Il est vrai que nous ne connaissons pas le nom de cette personne, mais nous connaissons sa profession, que je tais en public pour des raisons de confidentialité. Et nous avons situé la date de son arrestation comme indiqué dans nos écritures, au paragraphe 204. Date que nous avons affinée, certes, au vu de la totalité de la preuve. Par ailleurs, P1737 fournit de nombreux détails. Et je vous renvoie au transcrit français, T44, page 42, ligne 14, à la page 47, ligne 20. Précision aussi du lieu de l'arrestation. La personne visée dans l'incident N a été arrêtée dans un quartier de Bangui, arrestation lors de laquelle M. Saïd était présent, de même que le général Rakis. Et P1737, par sa position de témoin initié, a observé les membres Séléka battre la victime avec des ceintures militaires ligotées selon la méthode Arbatachar et interrogé sur ses liens avec Bozizé. P1737 a déposé que pendant les actes de torture, M. Saïd et M. Adam étaient présents. Et je me réfère au transcrit français T44, page 46, de la ligne 18 à 27. La victime a été enfermée dans la cellule souterraine et l'existence de cette cellule est cohérente avec la preuve fournie sur ce point par d'autres témoins de l'accusation. Pour la preuve de P1737, je me réfère au transcrit T44, version française, T44, page 39, ligne 13, à page 40, ligne 16. Et pour la preuve fournie par d'autres témoins sur l'existence de la cellule souterraine, je vous renvoie aux paragraphes 116, 197, 212 et 271 de nos écritures. Bien plus, l'arrestation et les sévices, qui sont décrits dans l'incident N, ne sont pas un acte isolé. Ces actes sont conformes au schéma systématique que la preuve a relaté tout au long du procès, celui d'arrestation arbitraire, de maltraitance et de torture et de persécution des civils, perçus comme étant partisans de Bozizé. Par exemple, P1737 a aussi participé à d'autres arrestations, comme celle de P1289. Son témoignage corrobore le récit de P1289 concernant l'arrestation de ce dernier et sa détention. Sa preuve se recoupe donc avec d'autres éléments au dossier. En définitive, le témoignage crédible et fiable de P1737, corroboré par d'autres éléments de preuve, suffit à établir la responsabilité de l'accusé pour cet incident, au-delà de tout doute raisonnable. Enfin, je voudrais terminer en adressant l'incident H, qui est relatif aux personnes arrêtées et détenues à l'OCRB, après avoir été accusées d'avoir distribué un feuillet ou tract appelant à une opération ville morte. Cet incident est visé au paragraphe 468 à 474 des Écritures de la défense. Dans ces paragraphes, Madame la Présidente, Madame et Messieurs les juges, la défense vous invite à vous baser sur le droit centrafricain pour justifier un défaut de conformité aux garanties procédurales. Toutefois, la loi est claire. La détermination du caractère illégal du crime contre l'humanité d'emprisonnement ou autre forme de privation grave de liberté physique ne se fait pas sur la base du droit national. Le troisième élément pour ce crime, sous l'article 7.1e du statut, est explicite. Ce qui importe, c'est qu'il y ait eu violation des règles fondamentales du droit international. Tout d'abord, pour ce qui est de la base légale de l'arrestation, la défense se réfère à la disposition dans le Code pénal centrafricain sur l'acte de nature à compromettre la sécurité publique, au paragraphe 311 et 468 de ces Écritures. Cependant, la preuve démontre que les arrestations étaient en réalité arbitraires. Par exemple, en ce qui concerne P1743, P0358, P2263, P2295 et P1180, 3 détenus n'ont pas été informés des raisons de leur arrestation. P1743 a témoigné, je cite, « Nous ne savions pas pour quelles raisons nous étions interpellés ou arrêtés ». Fin de citation. Et je me réfère au transcrit français T86, page 32, de la ligne 2 à 4. P2263 a témoigné. Ils n'ont pas répondu lorsque nous avons demandé pourquoi ils nous amenaient. Fin de citation. Et je me réfère à sa déclaration, car OTP 2130 6271 au paragraphe 18. P2295 a témoigné qu'il ne comprenait pas ce qu'il se passait. Il a ajouté, je cite, « Je ne savais pas où ils m'amenaient. Ils ne m'ont pas dit pourquoi ils m'arrêtaient, ni quelle infraction j'avais commis. » Fin de citation. Et je me réfère à sa déclaration en français, car OTP 2135 1852 au paragraphe 15, 16 et 18. Quant à P1180 et P0358, même s'il savait qu'il leur était reproché de renverser le gouvernement, leur arrestation était arbitraire car motivée par des raisons politiques. Il s'agit là, en réalité, d'un acte de persécution. En ce qui concerne en second lieu la violation des droits fondamentaux pendant la détention, P1743, 2263, 2295 et 1180 ont été torturés et détenus dans des conditions inhumaines. S'agissant des actes de torture, la défense parle de contradiction. Elle indique au paragraphe 475 de ses Écritures que les témoins, je cite, présentent des versions très différentes des violences qui auraient eu lieu à leur arrivée à l'OCRB. Fin de citation. Bien au contraire, les récits sont cohérents et se corroborent. Ils ont tous décrit le déshabillement, le fait d'avoir été forcés de s'allonger face contre terre, d'avoir été couverts de boue ou d'un mélange eau-sable, puis sévèrement battus, certains précisant à coups de fouet. Et P2692 détenu au même moment, évoque cette même scène dans sa déclaration. Et je me réfère au paragraphe 33, car OTP 2130 6685. Il témoigne. Je me souviens bien d'un autre cas d'acte de violence. Un jour, un grand groupe de prisonniers est arrivé dans la cour. Les Séléka les accusaient d'être impliqués dans la préparation d'un coup d'État contre Diotodia et dans la distribution de tracts. C'était avant qu'ils ne soient battus. Les éléments qui disaient cela parlaient Sango. Ils ont demandé aux prisonniers pourquoi ils se mêlaient de politique et de la production de documents réclamant la démission de Diotodia, lui qui avait souffert dans la brousse avant d'accéder au pouvoir. Ces prisonniers ont ensuite dû s'allonger par terre sur le ventre et les éléments Séléka ont lancé du sable et de l'eau sur leur dos nu. Ils ont alors été frappés sur le dos avec des chicottes. Après cela, leur dos était en sang. Fin de citation. Pour nier l'existence de ces actes de torture, la défense invoque l'absence de certificat médical au paragraphe 475 de ses écritures. Cet argument ne peut convaincre. Bien sûr, cela aurait été idéal, mais un certificat médical n'est pas nécessairement requis. L'article 69.4 du statut consacre la libre appréciation des preuves et la Chambre évalue leur force probante, même en l'absence de preuves matérielles. Dans le jugement Ongwen, par exemple, qui se trouve à la page 4 de notre table des autorités, et je me réfère aux paragraphes 1471 et 1472, la Chambre a reconnu un viol sur la base d'un récit détaillé et cohérent, sans exigence de certificat médical, tenant ainsi compte des réalités des zones de conflit. En l'espèce, les témoignages sur les tortures subies sont suffisamment circonstanciés et corroborés pour remporter la conviction de la Chambre, au-delà de tout doute raisonnable. De surcroît, la défense, au paragraphe 474 de ses écritures, invoque les différences de peine qui ont été prononcées par le tribunal de grande instance contre 4 détenus pour démontrer que le processus aurait été impartial. Or, une peine, quelle qu'elle soit, ne peut justifier rétroactivement une arrestation arbitraire, des actes de torture, ni des conditions de détention inhumaines.
How much more time do you need, counsel?
I can finish in 1 minute.
Please go on.
Les arguments soulevés par la défense ne sont pas de nature à convaincre. Bien au contraire, la preuve au dossier établit la responsabilité de M. Saïd pour ces incidents, au-delà de tout doute raisonnable. Madame la Présidente, Madame et Messieurs les juges, en conclusion, non, les actes de torture subis par ces détenus ne sont aucunement justifiables et ne relèvent certainement pas du droit pénal centrafricain. Ils sont punissables en vertu du statut de la Cour. Ils constituent aussi un acte de persécution. L'incident des feuillets ou tracts illustre bien la politique menée par les Séléka, celle de réduire au silence par la violence. Je vous remercie de votre attention et après la pause, ce sera mon collègue Thomas Bifoli qui répondra aux arguments de la défense sur les modes de responsabilité.
Thank you very much, Ms. Saudachi. Mr. Prosecutor, I see you wanted to stand. Do you have anything to say or? Okay. So we're going to have a short break here, and when we come back in 30 minutes, we'll hear from the next prosecutor. Is it Mr. Bifoli? Yes, to continue with the prosecution's address. So I rise the court for 30 minutes, please. Thank you.
All rise. We would away.